Recreational marijuana became legal in Illinois last January, and since then a power struggle has been underway. Legal marijuana complicating the hiring process for many, including a handful of attorneys offered jobs months ago by the Cook County Public Defender's Office. Their offers revoked when drug tests came back positive for marijuana. Tonight we've learned that after the I-Team started asking questions, the policy is being changed and the attorneys are being asked to reapply.
There is some kind of stigma.
So you have this situation where the public defender, Mr. Mitchell, he's supposed to have the ability to hire who he wants in order to represent his clients, and then you have bureaucrats and administrators who are getting in the way.
Brittany Robinson and Matt Stein applied for open attorney positions in the Cook County Public Defender's Office. Both received job offers. Both of their drug tests were positive for marijuana. Both telling the I-Team they use recreationally.
As long as there's not a substance abuse problem, if a person's going to work sober, if they're meeting their duties to their clients, then that should be enough.
What I do on my own time does not affect my professional responsibilities. I don't think that people who drink alcohol outside of work. We don't look at the issue the same way, but legally it is the same.
A Cook County spokesperson says their offers were revoked because the positions in question were previously noted as safety-sensitive positions. Anyone who tests positive for any controlled substance, including marijuana, in a safety-sensitive position is prohibited from being employed in that position. The new public defender, Sharon Mitchell, in a statement to the I-Team said, "Our position has never changed. Their alleged consumption of cannabis, whether for medicinal or recreational purposes, should not be a factor in determining whether they should be offered a position."
We're in a crazy situation. I mean, the state of Illinois came out and told everybody marijuana is legal.
Cook County officials say the policy was just changed because Public Defender Mitchell requested to reclassify the positions as not safety sensitive. A drug test is no longer required, and the attorneys affected have been encouraged to reapply.
Then there's this gray area of the law that doesn't really tell you what your rights are.
Employment attorneys say drug policies can be confusing for both employers and employees. Two state laws on the topic appear to contradict each other.
They passed a law that says you can't be fired for using marijuana on your own time. And then there's this ambiguous law that still is interpreted to say that employers can fire you if you fail a drug test for marijuana.
State Representative Kelly Cassidy sponsored the law to legalize recreational marijuana here and is now advocating for legislation she says will clear up confusion and protect employees' rights.
We felt like it would be more appropriate to put in place these protections that, again, make clear that testing when there's a question of impairment is absolutely an appropriate decision, but that folks who aren't in public safety positions shouldn't be subjected to this. It's a legal substance.
Stein and Robinson say they hope the revised policy saves future applicants from the struggle they have been going through for the past 6 months.
This is what we wanted to do. This is why we went to law school, is we want to represent people who need a voice.
I just don't want this to happen to anyone else.
Even as the marijuana policy power struggle plays out, both Stein and Robinson tonight say they are reapplying for the assistant public defender job.